tonight, I'm thrilled to have a panel of experts, legal experts, intellectual property experts, and I would also like to consider each one of them a friend. IP is something that everybody hears about. It's such a big deal in so many circles, but there are also so many misunderstandings, misconceptions, and downright wrong information out there. And so tonight we wanted to do a panel discussion with people who know that element in and out like the back of their hands, to provide us with down-to-earth, common sense, practical, applicable, actionable tips, tricks, and mistakes not to make when it comes to IP. The other thing that we are starting with this evening is that I am going to be making a shameless plug that do not try to do IP alone. It is not a backyard do-it-yourself exercise. Get the experts involved up front. And please, any one of them or all of them are here to help us. They're part of our chapter. They're here to help us. They're giving up their time freely tonight. Please come up, talk to them about your particular situation, see what they can do to help you on an individual basis, okay? Now, that being said, what I am going to do is I'm going to introduce them by name only. I'm going to put my rear end there, and then they can give their own bio, okay? First of all, I would like to introduce Mr. Jeff Agnor. Jeff is a founding partner of the Howard County law firm, Davis, Agnor, Skalny, and Rapaport and Skalny. I'll get it right one of these decades, okay?
That's good.
Jeff has been a huge supporter of us. Jeff is a business attorney par excellence, and I'll let him explain the breadth and the depth. I'd like to introduce Mr. Mike Antone. Mike is the IP expert at Jeff's firm and handles a lot of the patent and detailed IP work. I would like to introduce Miss Kimberly McLean. Kimberly has her own firm, McLean Law, and Kimberly has spent her entire career in the world of intellectual property, specifically as it relates to patents. She spent 20 plus years, I think it was, give or take, as a primary patent examiner with the USPTO.
10 years.
Oh, okay. And then I would like to introduce Barbara Pitelli, who is a partner in Inflection Point Law. Barbara has been a very active member of our chapter. She's a dear friend, but she also brings a wealth of small business, startup, law and IP experience to the table, and she'll be sharing some horror stories and things not to do. That being said, Barbara, I'll let you fill in the blanks. How's that?
Hi, thank you, Chris. So again, I'm Barbara Pitelli with Inflection Point Law. Best way to think about me is I'm an outside general counsel. So I help businesses, oftentimes small businesses, navigate their inflection points of growth from formation all the way through to a merger and acquisition. So a lot of my clients are not only commercial technology clients, but government contractors as well. So I do both sides of the coin, and I help them commercialize, license, sell their IP.
Hello, everyone. I am Kimberly McLean. I'm the founder of McLean Law. And as Chris said, yes, I have been working in patents forever. I spent a decade working at the patent office, primary patent examiner, doing examination on cases in cache and network systems. Since then, I've worked at several other firms. I started my firm about 4 or 5 years ago, And I work with a lot of startups, small inventors, small companies, helping them do their patent prosecution work. And I do a lot of software stuff too.
I'm Jeff Agnor with Davis, Agnor, Rapaport, and Skalny, LLC.
I'll get it right one.
Okay, got the LLC right. And I've been, I am one of the founders of the firm, and I've been practicing for 30-some years. And my area is general business, transactional work, do a lot of M&A work, and I think I'm here to give the perspective from sort of the transactional lawyer's perspective on preparing businesses for the M&A transaction and how important intellectual property is to that. I know enough to know, having done many deals, that when companies come up short on their IP, it's because they didn't talk to these folks and early enough. And so I do a lot of traffic directing in my practice of trying to get people to talk to the right people, clients to talk to the right people about protecting property, which is intangible, which folks don't always know they have or should have. So, in other words, I know nothing about IP, but I know the folks who do.
Mike?
Hello, everyone. I'm Michael Antone. I work with Jeff at Davis, Agnor, Rapaport, and Skalny, LLC. And my practice is primarily patents, trademarks, operating agreements, service level agreements with various operating companies. I've worked as an engineer in telecom and in power systems and I've also worked in venture capital before going back into the law firm practice. While the business folks here will talk about how they kick things to the IP people, well, as you'll find out here, intellectual property and protecting intellectual property is from the business up, from the ground up. It's the way you've got to conduct business. And the first people you'll probably touch in trying to protect intellectual property will be Barbara or Jeff, because you've got to build a foundation before you can even worry about things like copyrights and trademarks and patents.
Thank you. So to start this off, and what's going to happen is Jeff is going to be kind of my co-moderator tonight, because I know enough about IP to do two things. One is to be incredibly stupid, and roll that into two, which is to be incredibly dangerous. So I think I know the questions to ask, but I also felt like it was good to have someone from the legal perspective keeping my tail out of hot water. So Mike, you raise a point that we discussed at lunch the other day, and that is that there is this common misperception that the four elements that everybody hears about of IP is but one component of the total intellectual property perspective. And you put it so brilliantly at lunch the other day. Could you kind of share with everybody how you said it or what you said, and let's start off the discussion that way.
Well, as you said, Chris, people think about patents, trademarks, copyrights. Those are the actual protections that you put in place, right? But it really comes down to the first question: is what is your intellectual property, right? And it's all your intangible assets. It's your know-how. It's the way you do business. It's your customers. It's your employees. It's everything about your business. In fact, basically it is your business, right? Your business is not your lease. It's not your chairs. It's not your computers, right? All that stuff, you could take them all away, you guys, and if they give you a bag of money back from the insurance company, you go out and you just rebuy the stuff and you just, and you carry on. So that's not your business. Your business is your intellectual property. And the reason in part of my introduction says, okay, there's more to protecting that intellectual property that you have to build from the bottom up in order to do that. Many businesses, in fact, the overwhelming majority of businesses will not ever be involved with patents. And Most businesses probably will never be involved with copyrights because they're specific protections, right? Patents are how you protect ideas that have been reduced to practice. Copyrights are how you protect creative works. So there's a lot of businesses will go on that'll never be the case. So, but we still have to protect the business, and so there's still a lot of intellectual property involved. And so I want to kick it kind of over to Barbara because she was talking about, just the basics
Right.
of how you go about protecting intellectual property.
Well, thank you, Mike. So, as Mike was saying, there's different types of intellectual property, and you could certainly register your trademarks and copyrights. It's all in your head, right? Everything that's in your head could be an intellectual property. But I look at, there's 4 basic ways, fundamental things to do. And as he was saying, starting from the basics, the ground up, first thing, only do business with people you trust. That's number 1. And that is really on the client side. We can't tell the client who to do business with, right? They have to do their own due diligence. If you're coming to me and you're saying, I want to distribute my product in China or Russia or India, I'm going to say, well, wait a minute here. Who is it that you're doing business with? Right? Do you know them? Have you done business with them before? Do you know other people who have done business with them? Because once the IP goes away out of the country, it's gone, right? So fundamentally, know your counterparty. Trust them. If you do not trust them, don't do business with them. That's rule number 1. When I first became an attorney, my partner said to me, rule number 1 is only do business with people you trust. Rule number 2, which is our second layer or foundation, is write the contract as if you don't. So, step number 2 of your foundation is a contractual risk mitigation. There's provisions that you could put, whether it's an NDA in place, a proprietary information and assignment agreement that you make your employees sign, non-competes and restrictive covenants to prevent your, competing with you in the same technology area. You could put in place your license agreements, how you're slicing and dicing your license from geographic to industry to duration to perpetual to, whatever way you want to slice and dice a license agreement, selling your technology, adding your special sauce and sending it off to another, distributing in another place, right? So that second layer is your contractual layer. Your third layer is your registration. So as Mike was saying, and what Kim does also, is registering your copyright, your trademark, your patents. And that gives you certain protections. It's true, not many clients need patents and not many clients need to register their trademarks. But there are certain benefits that you get for doing so. And I'm sure we'll get into that later. But then the fourth layer of importance of your foundation is insurance. There's things that you can't mitigate, right? And that's where insurance coming in with either cybersecurity insurance, somebody hacks into your system and steals your IP, which can certainly happen. I've had clients have that happen with former employees. Come in, start mucking with their system. You need to have some sort of insurance to cover that risk because you can't mitigate it in other contractual or registration methodology.
I don't know that I could have ever said it any more eloquently than that. Now, I'm going to ask for a show of hands right now. I want everybody to raise your hand and promise and swear on a stack of business cards, you will never, ever, ever take the DIY approach and go out and Google it. This is not intellectual property according to Google. Hopefully you'll be hearing some of the horror stories of people who tried to do it themselves and the problems they got into. But this is as Mike said, this is an area, this is your business. It is your most important asset. If it's not what's up here, you don't have a business. Therefore, make sure you're taking the right steps to protect yourself. Now, that being said, let's talk briefly about the major forms of protection at level 3, which is your registrations.
Yeah,
Okay, and we're talking patents, copyrights, trademarks, and then there's a fourth called trade secrets. And we'll get into that, but it's a slightly different animal. So, that being said, everybody hears about patents. Kimberly, give us, give us a tutorial of patents, what's patentable, what's not, in this age of intellectual property and AI and technology. It used to be you could patent a Coke can or a machine or a widget, but now it looks like the vast majority of patents are being issued for soft stuff, intellectual stuff. Am I close?
So, okay, so a lot of that is governed by the statute. So the statute stipulates what is and is not patentable.
Okay.
So widgets or articles of manufacturers they can be patented, but the other requirements is that it has to be new, non-obvious, and it has to have some utility. So what could happen in some of those areas is if you have a crowded space, it's going to be a little difficult to create something that's new or non-obvious, depending on what it is. I mean, I'm sure it's only so many ways you can make a pen or, some small widget. So perhaps that may be what you're speaking of in terms of the innovation in that area. It's only going to go but so far. So, but yeah, the statute states that, a process, a article of manufacture, a machine, or a chemical composition, those are the 4 categories of things that can be patented. And the requirements are going to be, it has to be new, and it has to be something that's not obvious, and it has to have some utility, some functionality. And you can have utility patents versus design patents. The design patents, I'm starting to get a lot of work in that area. People are starting to appreciate those a little bit more. But it's more of the aesthetics, how something looks, the ornamental features. The utility patent is going to protect the functionality of what your innovation is doing. So you would want to, if you're thinking, oh, I have an idea, or I have this prototype or device I'm developing, I want to know if it's patentable. Of course, the first thing I would recommend is maybe try to consult with an attorney, because I basically just told you what the rule is. I don't know if that means anything to you guys, right? So you're going to be like, oh, but if you look it up or you Google it, that's what it say. So the better way, if you can't get a consultation with an attorney, perhaps maybe you could do some searches. There's a database at the patent office. You could search the database and see if there are other similar things close to what you're doing. That would give you a sense of, okay, this could be something that is patentable. But ultimately, if it falls in the category and it meets the requirements, then you can at least file a patent application. Now, whether you'll get a patent is a whole nother story, but you can at least file an application for it.
Okay.
And then if you want me to get into the prosecution area a little bit.
While we're on patents, Leah, walk us briefly. Give
Okay.
us kind of the Cliff Notes version.
Okay.
Let's stay on patents for the time being.
Right.
Let's not
So-
mix metaphors here.
Okay, so the point I'm trying to make is you could possibly, it's more probable to have something that you could file a patent application for. The issue is going to be, is it something you can get allowed through the patent office? So the big issues are going to be the novelty and the non-obvious. Novelty is pretty straightforward. Is there something else out there in the public domain that's doing the same thing you're doing? The obvious standard is a little subjective. And so that's where, for me, I run into my clients have issues a little bit with the obviousness rejections, because they think, oh, my device is longer, or I have a cache instead of a DRAM and stuff like that. This is different. And so that's really why you want to get someone that is seasoned in this area, because patent examiners, and I used to be a patent examiner, they have the broadest reasonable interpretation. So it's not literal. So, and this happens all the time. The client's like, oh, my device has 20 shelves, and I'm just simplifying it so you guys understand what I'm saying. But they'll tell me what the distinctions are, but I'm pretty sure we're going to get an obviousness rejection for those. So the issue is sometimes, can you get through the obviousness rejection? So another reason why you want to make sure you have a patent attorney, because they're going to always recommend that you have a patent search done. So you kind of want to have a sense of what the landscape is before you even file it. You know, what else is out there? That's another way. I mean, how can you determine or even assess yourself if it's new or not obvious if you don't know what the landscape is? So you need to have a search done. And it's good to have a patent attorney do that because they have a better sense of, okay, this could be, you know, interpreted as a 102 or 103, and the inventors probably really don't have that same judgment. So you want to have a patent search done, have a patent attorney write the patent application. We know how to vary embodiments, add other information in patent to give some wiggle room if we have to make amendments to your claims to get it through prosecution. And so that's basically the process. You're going to file a patent application, you'll get a response from a patent examiner. They're going to tell you it is or it's not patentable, here's why. They'll give you the rejections, and then you have to file a response, and it's a back and forth sort of negotiation. If you can get enough information in the claim that they're satisfied with, and then you get a patent issued. Otherwise, there are other things you can do, but for time's sake, that's the general process.
How long does that take?
Well, honestly, it can take years.
What was the fastest one you ever saw go through?
So they do have the accelerated examination process, and so I've been having better luck actually with getting things allowed through that, and that was less than a year. But you have to, you know, you pay a fee to have it expedited, but I don't know why. It seems like people are having better luck with that, the accelerated examination in terms of getting things issued.
And there you pay acceleration fees. But if you've got something where it's very important for investors or whatever it might be, it's worthwhile. And you typically don't go into an accelerated examination unless you think you got something good. Mm-hmm. And there's actually some of the examining corps is some of the examiners that are looking at some of the more leading educations. So the allowance rates when you go through the accelerated examination are higher. But it's typically, if it costs a small inventor to file a patent application, let's call it $800, it costs another couple thousand on top of that. So people you don't go forward you don't go into that process unless you got the good stuff, right? You may say, I got 10 inventions on this product, but this is the good one, and all the rest of them are like small changes or whatever it might be. So you say, I'm going to take this one through the process. But things have changed, and things are moving a little faster.
Yeah.
I have a patent issuing tomorrow that I filed last March.
Oh, wow.
It's crazy. It's the shortest time ever, but it usually takes years before you even hear back. It just gets into the queue. Depends how busy things are. So, you want to segue into trademarks?
Yeah, let's move into trademark. Why don't you pick up and run with that, Mike?
Okay, so, the patents, and the way things move is patents are very involved. So there's a fairly significant cost. You're going to get into the thousands of dollars with patents. And as you go down, we'll talk about trademarks, much less involved, but still involved. Then we'll get the copyrights where it's ministerial, the registration process. But trademarks, to touch back on the thing I said earlier, many businesses, if not most businesses, won't do copyrights. Many businesses, if not most businesses, won't do patents. Everybody, or nearly everybody, should do trademarks. And the reason I say that is, trademark is about protecting your brand. Okay, it's about marketing. If you're spending marketing dollars without protecting your brand, you could be, exposing yourself and causing yourselves a lot of pain and a lot of angst and a lot of money over time if you don't do it. And trademarks, I tell people, trademarks are a no-brainer. when you look at the cost of marketing, a trademark application, in its simplest form,
You say trademarks are no-brainer?
trademarks are a no-brainer.
As far as,
For almost
needing one.
as far as needing one, registering your trademark is something that nearly everybody should do. And there's the reason. One of the reasons for it is it's fairly inexpensive. Your basic trademark, depending upon is going to cost you anywhere between $500 and $1,000, depending upon what level of involvement you have. And your first action, if you've done a little bit of legwork up front, your first action is going to be somewhere in 3 to 6 months. If there's no real problems with it, it'll issue in another 3 to 6 months. So within a year, for anywhere between $500 and $1,000, you could end up with your trademark being registered. Yes, sir.
Is that 500 and 1,000 just the fees of registration or including attorney?
It can include the attorney. It's when you think about it in terms of your marketing budget, let's just call it $1,000. If you end up prosecuting an application, it can cost you a few $1,000s. But even then, even if we said $3,000, when you look at it in the context of a marketing budget, right? So say we go in there and there's problems in the trademark office that requires the back and forth, right? If you go in clean and you make it out without the attorney having to go back and forth with you, the trademark office has attorneys that do the examination. That's all they do all day long is examine trademarks. But when you look at if you come out the other end and $3,000 later, you've got a trademark, you don't have to do anything other than use that trademark for 5 years. And then you have to go in and you have to file some paperwork, which could cost $500 to $1,000, and to declare that you're still using the mark. And then 5 years after that, you have to tell them that you're still using the mark. And then once you get to 10 years, they say every 10 years you have to tell me whether you're using the mark. So you're looking at, on an annualized basis, $100, $200 of your marketing budget goes to maintaining your trademark. And then you look at the downside of not doing a trademark. Is all of a sudden it comes to light, you get a little letter from our litigator friends that says, hey, you're using my trademark. And then you have to go deal with rebranding. And you have to go out and all the goodwill, all the work you've done to build up your name now gets flushed. And you've got to go through the whole thing. You've got to, from labeling to your website to everything you got to redo. So, it's extremely important to do that work up front. And, unfortunately, I've been working with, it's not unfortunate, I've been working with startups for a long time, but I've been in startups, I've worked with startups, I've worked in firms that have funded startups. And so I know what it's like. And then I had to send the company a cease and desist order, a letter, because they had they were doing a Kickstarter campaign, and they used my client's exact trademark for the exact product. And I felt terrible, but there's nothing you can do. But these people had gone through all their branding, run the Kickstarter campaign, with a lot, and they put the logo, on the device. So they had to reshoot molds. They had to go through and completely rebrand. Okay.
How could they be so dumb?
That's an excellent question.
There's in the modern era, there's nobody above the age 5 and below the age 90 that should be able to do an internet search, right? And so when you're going to do branding, the first thing you want to do when you think of that's a really cool name, is do an internet search.
You all know you can do uspto.gov and do a search of a trademark. Just type it in and find at least a word by it. And I should note, we keep using the word mark, a trademark, as if it's a logo, a drawing, or something, a stylized look. A trademark can be a name, it can be a word mark, it can be a word. So that can be a little more challenging if the word is descriptive or generic. But if it's kind of funky and cool, and Apple computers have nothing to do with apples, fruit, right? So that's a good trademark. Bright, shiny red apples might not be trademarkable because it describes what an apple is and you're advertising an apple, but a word can be a trademark.
My question is not having an unusual name. I mean, Pablo Picasso can trademark his name. It's very unique. My name, for instance, is very common. And I read somewhere you can't trademark a common name.
It depends, I would think. You guys correct me if I'm wrong, but it's really intended, your trademark or your service mark is intended to understand the origin of the product or service, right? So Apple actually started in the education environment with their computers. That's where Apple, they give the teacher an apple, right? And that's where that concept came. But if you were trying to trademark Macintosh apples as apple, right? Probably can't, because it's a common word and you can't prohibit somebody else from utilizing that common word. So it depends on your name and the type of service or product that you're providing. I'll give you an example. I know Mike said, hey, it's about $500,000 for the registration fee to do a trademark, but it can get pricey pretty quickly. For example, Jeff mentioned a word mark versus a design mark, your logo, right? So if your name is Inflection Point Law, and I have that little swoop logo, right? Those two things would need to go separately for registration. I had a client one time, and telling stories, I had a client one time that was a sculptor, and he wanted to do his word mark, the name of his business, Dragonfire Studios, and his image of the logo to register. So now you've doubled your cost because you're doing a word mark and a design mark. So you've doubled your cost of your trademark.
Well, you've actually applied for 2 trademarks. You
Correct.
didn't double your cost, you went
Right.
for 2, you're protecting 2 separate things.
Right, so you're protecting 2 separate things, you have twice the cost. In addition, it has to be in commerce, as they said, 5 years, 10 years, you're checking, right? So before you could do anything, it has to be in commerce. You have to take a picture of your design or your word mark on the product or service that you're shipping out. You have to show pictures and things of that nature. In my case, or my client's case, he was doing sculptures in both resin and bronze. Again, now he had to do it for each, the word and the design, he had to do it in both resin and such. So it depends on your service. It's really cut and diced, and you guys could correct me, you do this on a day-to-day basis. I don't do it on a day-to-day basis. I've seen a few of them done, but it's whether it's a software, what's the specific software that you're trademarking, what's the nuts and bolts of the product or service that you're trademarking. Everything that you're doing has to be registered separately.
Right, so that's where the addition, that's what I was just going to add, that the more classes you have to register
Classifications, that's
a mark in, that's more cost. So if you just do one registration and one class, then, that's not that expensive. I think it's $275, something like that.
Right.
Yeah.
250 is good, a
Something
good
like that.
ballpark, because
But
sometimes
if you now have to register that in 7 other classes, most part of that time 7, so that's where the cost can come up.
And, right, and just to step back slightly and agree with everything said, right? I had said trademarking is about your brand, right? But as Barbara said, the trademark is meant to identify you as the source of the goods. right? And that is the purpose, and that's, that is what branding does. Right? It's identifying you as a source of your good. To your specific question, if it's your particular name, we'll just, we'll say, that there may be, you're able to protect that, but you can't protect it from other people with the same name. But if you have somebody that was coming in and using your name, it may be actionable because it's deceptive.
Well, I know there are
So-
several artists out there on the internet that have my name, but
Right.
they haven't added ART to the end of it, because that's part of my brand.
Right.
Even like on the internet, the domain, I mean, I took the catherinenelson.art domain.
So Catherine and I have so we've kind of scripted this. This is a back and forth thing. This is the unrehearsed script, but you've gotten to the point where, what can you trademark, right? And I think Jeff was starting to say that things that are trademarked cannot be merely descriptive. So art, right? Catherine Nelson's art. That's merely descriptive of the service that you're providing. Okay, it can't be if it gets to be merely descriptive or it gets to be generic. A lot of people come to and they're like, I want a name, as eclectic art. Like, well, you can't do that. You're describing what art you're providing. Okay, but if you come up with Apple, right? I got Apple for computers, Amazon for web services.
I was going to say,
Yes, sir.
I actually filed a trademark last year for my company name. I'm a patent insider. I'm a patent agent. We did 10 years at the patent office as well. But the trademark examiner called me and said, yeah, you're going to go right through. And then I got a phone call like a week later. They said it was totally descriptive. They said, you work at the patent office. You are an insider. And so we're going to put you on the secondary register. So I'm going through that process. But, I mean, how would someone navigate that? If you have your branding built, you have your design, your logo, you have your word mark. How do you navigate around something that's descriptive?
Well, fortunately, it sounds like you got to be descriptive. So they put you on the secondary register, which is a lot deeper than, if anybody has any questions about that. When you have something that's descriptive but not generic, if you're trying to call like an escalator for moving stairs, you say, well, that's actually descriptive. That's actually the name of it, right? This is a bottle. This is a chair, right? You can't take those things. I don't care if you call it chairs, chairs, or whatever you want to do, right? But you can't take a generic name for it. And there is this tendency for people to want to name their business that describes what they do, and you're like, that's fine, but you can't protect it. The best things are arbitrary and fanciful, and suggest a relationship to perhaps the service or the product that you're providing. We talk generically about trademarks, but trademarks are technically applied to goods. Service marks apply to services, but the whole class itself is called trademarks. Okay, so let's see. There was somebody had mentioned something. In the state of Maryland, right, Barbara mentioned commerce. So you have to, for a federal trademark, you have to use it in interstate commerce, and meaning across state lines, which used to be a challenge for some people. But in the internet era, if you put up a website, you're engaging in interstate commerce. And so for a U.S. trademark, you can file what's known as an intent to use application if you're figuring out your branding. Because what you don't want to do, in the old days, you would have a big company working on a marketing project for 6 months, but they haven't used it yet because they're getting the whole thing together, they're ready to do a national rollout, and then right before you start using the mark, somebody files a trademark application and starts using your mark, and you're stuck because now they have national rights. So you can file what's known as an intent to use trademark, which can buy you, once you make it through the process, can buy you like 3 years on top of it. So you can get 3 to 4 years until you can start using your mark. Other people are still, if you're doing business within the state, you can file in the individual state where you live, where you're doing business. In the state of Maryland, you have to have use. You have to file it in paper, and you have to file original signatures, and you have to file 3 specimens. It's actually kind of annoying.
A couple other things I want to bring up that we haven't talked about. So there's a common law trademark. So who has ever seen a name or a logo with a TM next to it? Right? So that's common law. It's not registered, but you're asserting that you have the rights under common law to that mark. When you do the R with a circle around it, that means it's registered. You actually have it back from the
trademark office,
trademark
yep,
office
USPTO.
to that you are registered that trademark or service mark. So so that's one thing I wanted to talk about, and then the other was escaped my mind on trademarks. Anyway, I'll
has
come
a
back to
question.
it.
Asher?
Is trademark, so you said there is a state trademark, a federal trademark. Is there also, once you get the federal trademark, is it only for the US boundaries, or does it span?
Intellectual property rights in general are jurisdictionally limited. So a Maryland trademark only applies to Maryland, a US trademark only applies to a US, and then you've got to go to the jurisdictions around the country. Like at some regions like Europe has a European trademark.
Yeah.
So
If I could, let's not go down the international, or let's not get outside of the US right now, because we still have a lot to cover. So that, now,
in the,
go ahead.
in the interest that this, do you want me to just give 30 seconds on copyrights?
Yeah, that's exactly where I was gonna go, and then we can talk.
Unless you want to do it, Jeff.
So, I could, but go ahead.
Well, we were talking about, there's a lot of work, there's examinations that are done at the patent level, and then there's examinations that are done at the trademark level. Copyrights are very ministerial. You pretty much, you go on, if you're capable, if your things that you're copywriting are capable of being done, you can go online, you fill out a form, you pay the money, and they don't do any examination. It just goes into the queue, they register it, and you have a registered copyright. It goes from being that simple to being incredibly complex when you think about how do people get paid when people are downloading their music or they're streaming it on Spotify or Apple Music. And it gets insanely complex when you think about how every song that gets played, somebody gets paid, and how that tracking and everything else. So it goes incredibly complex, but at the upper level, it's incredibly simple. We can talk a bit more about that later, but
Go ahead.
I'm going to talk about copyrights. So a copyright is a right in creative work. That's the term. If you go to the U.S. Copyright Act, which, by the way, their website for the U.S. for copyrights at the Library of Congress, if you go to their website, they've got all of these little pamphlets online that you can download and look at, and they have one on this basic copyright law. They have one on architectural drawings, musical scores, different things that are copyrightable, and it's the best government resource I think I've ever seen. It's very plain English, very easy to understand. So they lay out nice little definitions. One of the definitions is a work. It's a copyright is a right that one has in a creative work, meaning it doesn't mean you have to be brilliantly creative, but it has to be something original that you create. You can't
Put down
copy.
an intangible
Yeah,
medium.
you can't copy. The phone book or lists of things, but if it's a creative work, and as you said, it has to be reduced to a tangible medium, and that could be electronic, but it has to be reduced to a tangible medium, can't be up here, can't be a concept. And this is where, by the way, people get confused a lot, because I'll have clients come in and say, I want to copyright, or I want to trademark this thing I just wrote. They mean copyright. or they're getting confused with patents. So copyright has to be an original work that's reduced to a tangible medium. It's written, it might be software code, it could be an architectural drawing, it could be a painting, it could be a musical score, the notes on a musical score.
Audio.
So audio is a very broad range of what it is, but it all has one thing in common. It can't just be up here. It's not an idea. It has to be reduced to a tangible medium. It's something that's identifiable. So, and this is where I'll have clients come in and say, I've got this great idea, this great methodology, let's call it, for, let's say, how to do an online course on some subject. And it's a really cool way that I've done this, and I've put many countless hours and thousands of dollars into investing in this methodology, and it's really good. And I've got it here in this manual. And before I share it with others, is it protected? Well, it's not patented. It's probably not patentable. Or I'll leave it up to these two to tell me that. It's probably not patentable, and it's probably the actual words in that manual are copyrighted because exactly as they're laid out, and the exact drawings and things the exact rendering of those ideas in this tangible medium are protected by copyright. But the idea embodied in there is not. So, and by the way, the right is created automatically. So when, this is what, I love copyright law, by the way, because I think it's one of the most powerful ways to protect intellectual property, and the easiest to protect because it's automatic. When you create a work, you automatically, if you're the creator of the work, you automatically own the copyright. Now, for various litigation reasons, you want to file it in the Library of Congress, assuming it's not trade secret information as well. But you want to file it, register it at the Library of Congress. It's very inexpensive to do, and you just send it in with a fee, and you've done it. It's not like a process, like nobody's going to challenge your copyright when you file it at the trade. There's no examiner who's going to second guess your filing, I don't think. But here's the limitation. It is only the exact string of words or musical notes or things like that that you've actually protected. So anybody that you're doing business with or who sees how you're, they get a copy of your course materials and they see how you did it and they say, I could do that too. I love the concept. I'm going to go out here and do the same thing that you did. And they can imitate it. They just need to rewrite it differently. Now, when I say it has to be exact, it can't be deceptive, misleadingly similar to, but if you completely come up with a whole new manual and use the same concept,
Same methodology,
that's just called competition. You're imitating somebody in the way they do things. So this is where I run into problems as a transactional lawyer, as a business lawyer, and I've got clients who, this is where I know when to send them out. They come in, I wouldn't say it falls in the cracks, but so much of what we're talking about that's intellectual property isn't really protectable by these government protections. It's not patentable, it's not, the concept is not copyrightable, or it's not copyrighted. We're not talking about a brand here. I mean, there may be some brand material elements to that you can protect, but the basic concept is not. And because you're sharing it with others, it's not a trade secret. We'll get to that in a second, what a trade secret is. It ain't secret, because by nature, everybody's seeing this thing. So it doesn't fall into one of those convenient buckets. So then it becomes a really big challenge how you protect that. And I would suggest that if you're, to the extent that you can protect it, you're going to protect it contractually with restrictive covenants, assuming the other person's going to agree to do that. That could be a whole different course on how we do that. So much of what we're talking about, the big challenge is that if it were easily copyrighted, if it were something that was copyrighted, and the novel that you wrote brilliantly, it's very hard for somebody to imitate that. But the concept, that's where I come, that's the challenge for me as a business attorney. And the best hope I have for someone who can't maybe protect it with a restrictive covenant, that concept, that methodology, is, believe it or not, this is where trademark sort of creeps in. because as my client starts to use that methodology and becomes the toughest kid on the block with the best at what they're doing, people associate that with the mark, with the name, with the brand, and over time, and the longer the time that goes by, trademarks are like a very fine wine. They age nicely because over time, hopefully they do. They can go the other way too, but over time, goodwill accrues to that mark, and people start associating that methodology, that business model that you're using with your mark. It becomes increasingly harder for anybody to imitate it. At the same time, hopefully, they're getting their game down better. It's just the quality of what the service or the product they produce is superior.
Jeff, I want to tag on to your discussion on the copyright, because I think it's important for people to understand when or why they should copyright. So obviously it's very easy. You just go on the website and you register. I think it's like $55. So why would you register it versus not register it, I think is an important distinction. So Jeff mentioned, hey, wait a minute, this gets published with the Library of Congress. So think about that. Every book that's ever written that's registered, appears in the Library of Congress. Now, software is something that's commonly known to be copyrightable, right? So you could register the copyright. So as soon as you write down the code, you own the copyright to that code. The question is, do you register it? Well, if you register it with the Library of Congress, you've just made your code public to the world. Anybody could search, find your code. Now, if they infringe, if they steal that code, sure, you have a right, because you could go after them. How are you going to know that somebody stole your code, right? Think of how difficult that is. So it's not common, nor do I typically recommend that somebody who's doing software register their copyright. Saying that, there are times where it makes sense. If there is a document, let's say a how-to manual, a user manual, or some sort of documentation that you're going to be giving out that you don't want your competitor just to say cut and paste and copy it, right? You actually want to register it, so if it comes down the pike later on, that you could say, yeah, you took that entire chapter and you infringed. You want to register that copyright within 3 months of publication, or offered to the sale, or licensed to the public, right? Offering it to the public. And the reason for that is you get 3 rights when you do that. First of all, you get what's called per se ownership, meaning they have to prove you don't own it, as opposed to you having to prove that you do own it. Big difference, shifts the burden to the other side. The second right that you get is what's called statutory damages. That means and I forget the numbers, it used to be about $750 per infringement. So if somebody takes your image and they reproduce it thousands of times, you get a dollar value per infringement.
Per infringed work.
Per infringed work, right? So if they take 10 of your works and they infringe it 10,000 times, that adds up very quickly. As opposed to you have to prove damages. Very difficult to do when you have no idea what they've sold or what they've done with the document. And then the third right that you get, if you register it within 3 months of publication, is you get attorney's fees. Believe it or not, this makes a big difference. Because when an attorney says, and believe it or not, I've had this happen. I was literally watching the finale of a television show called America's Got Talent. Who's ever seen that show? Okay, so I'm watching the finale. I'd never seen it before, flipping through channels, and I am watching some guy contestant by the name of Prince Poppycock. He's dressed up in a night suit, singing opera to some woman dangling from the ceiling. and 3 months of publication. So then I could certainly prove that I owned it, and he owned it, and all this other stuff. But then it was a negotiation because he didn't want to spend the money
That's a really good point. Good story.
out of pocket.
Chris, can I ask, because this is something I was thinking about before on both levels, trademark and copyright. So let's say you are, just because I think for startups this would help, you're first to market at something. You're focused on getting your business going and you haven't done a trademark. Lo and behold, a year or so passes, someone else comes in and they're doing the same thing, but they go and they apply for a trademark. How's that going to play out for you? I mean, you can prove
Badly.
you're operating, and we talked about the goodwill, so if people are associating your brand, you could prove probably you were operating.
Did you have the TM on your?
In this case, I would say no, because I feel a lot of startups probably wouldn't think to do that. That's why.
So Barb mentioned common law protection, and I'm going to tell you more than I know about common law protection of trademarks, because that's why I'm here, to talk about more than I know. But, so my understanding is if you're using the copyright in commerce, the trademark in commerce, and you have protection in the area where you're actually using it, and that may be very limited. But if someone else, and then if you've been using it in this, I guess if you could prove you're using it in this area, and then someone else comes along and has subsequently registered it, you have a certain amount of protection for your prior use of the trademark, if you can prove that. But you don't have that whole, you don't necessarily have that national, that national protection, and a lot of this becomes an evidentiary problem as
and
well.
if they're better funded and have better lawyers.
So you're not going to be in a really good position, but you may not be in a very vulnerable position, at least within
You
this.
might be able to salvage some of it. So I think I remembered what I was going to say, the other point on trademarks that I was going to say. Think of trademark as not, hey, I'm protecting my brand, as much as you're preventing somebody else from utilizing. You're keeping people away from utilizing your name or your brand. And the reason why you can't trademark the word share is because everybody uses the word share so the copyright the trademark office will not permit you to take a common word and trademark it to prevent others from using it. They won't let you do that. That's why the word art, for example, you can't use.
But here's my question. Pablo Picasso, Kate Spade, they trademark only their names. But if you have a common name, like mine, Catherine Nelson, it's very generic, there's thousands of them, can I trademark that?
See if anybody else has.
Yeah, I think it depends. So with Kate Spade, she's a designer, right? That's her clothing line. So she's selling goods under Kate Spade. So even if she ran into a rejection at the trademark office, you can acquire secondary meaning for a mark that's descriptive if you show, people associate that particular name with your goods or services. It takes about 5 years to do it. So
already?
Yeah, so that's probably how she was maybe able to get that done. Have you've applied for the mark? And
No, I have not. I haven't considered doing it
okay.
yet.
So it generally goes back to what we were talking about earlier and what Barbara and Kimberly just took us on is intellectual property rights. The governmental grants are, generally speaking, they're the right to exclude others from using your IP. So a patent is the right to exclude others from using your invention. A trademark is the right to exclude others from using your brand and other marks that are confusingly similar to your mark. A copyright is the right to exclude others from using your expression in a creative work. So they're putting up boundaries. They're putting up walls, right? And that's and that's the problem you get into with common names, is that you can't prevent people from using their name. You can develop secondary meaning. A lot of people use pseudonyms for the very reason that you could register. You can do pseudonym protection.
I see a lot of hands I'm gonna ask you to just hold for a couple of seconds, because there's a piece of this we haven't even begun to talk about, but I think it's critically important, trade secrets. Let's get that out on the floor. There we now have a platform of options and possibilities to talk about. I'm gonna ask you, Kimberly, because here's why I'm asking, is I was working with a client 2 years ago. These guys were brilliant engineers and had taken the existing technology within the self-driving car space and developed a completely new methodology for being able to have the car see in 3D in any kind of weather, any kind of road condition with their technology. And we spent months, and they had hired a relatively high, not a relatively, a very high-priced law firm to file patents on certain pieces of it. Well, this is all stuff that came in subsequent iterations. And so the debate that we had there is it patentable? Their lawyers said, yeah, it's patentable. But in a practical business perspective, the minute you put a patent out or you apply, it becomes common domain, and therefore, even though we don't like it, somebody's going to steal it.
So-
and so the dichotomy or the problem we had is, do we patent it or do we go for the concept of trade secret?
Okay. So that's a very good point, and I talk to my clients about that all the time, and particularly with technology, the biggest thing you want to think about is, can somebody reverse engineer it? If you can reverse engineer it, then a trade secret does not help you. Okay, so a trade secret is essentially, it's confidential information that gives you some business advantage over your competitors that they don't know. And so you have to take measures by contract, you put confidential on everything. You want to minimize the number of people that have the information to keep it confidential, like the Coca-Cola formula. Nobody knows what that is. And so the second that someone independently finds it out, they could start making that product. But that was a great choice for them because no one still knows what the formula is. But in certain technologies, if you have really smart people out there, I mean, if they, particularly with some of the engineering stuff, if you can reverse engineer it, it's moot point to. So if you know that, then your best choice is to get a patent, right? Because they're going to figure out how it's made anyway. So you might as well try to get at least a 20-year monopoly on it if you can.
Okay.
So
let's now take all of this to the next step, and let's talk about what all this means when it comes to our businesses. At startup, in commerce, then the holy grail, theoretically, is an exit, a liquidity event, an acquisition. Jeff, that's what you do for a living, okay? And we talked about this at lunch the other day, and that is due diligence. And the fact that a merger, acquisition, an investment, an exit, it's not as if somebody announces it one day and the next day the money's in the bank. There is anybody buying you, investing in you, they are going to want to uncover every little amoeba that may be out there about you because they have to do it and protect themselves. So therefore, let's talk about that in the real world. What do we need to be doing? Because as I mentioned, it's always better to start today, thinking about the end game, and then what do we have to do incrementally in terms of our due diligence to prepare the due diligence for them, so that when it gets to you, you just pick up the phone and say, here's the package.
So if I could just describe what we're talking about when we talk about due diligence is a process, more accurately called an ordeal, that occurs at the beginning of an acquisition process. Let's say you've just gotten a letter of intent to buy your business. Somebody's showing an interest in buying your business. Maybe they've given you a purchase price, maybe they've sent you a letter, it's non-binding. So we're going to start a process. They always promise you we're going to have the purchase agreement signed in 30 or 90 or 60 days. It's going to close, and we all know it's 6 months. So that process starts. At the same time you're negotiating the purchase agreement, the other side is coming in and kicking the tires. They've given you at the very outset of this process something called a due diligence checklist or request, and it's pages literally of things that they're asking for. It could be financial statements, your governing documents, your employee manuals, and things like this. And there's always a section on there that has to do with listing your intellectual property, listing those in your company that have signed NDAs, that have signed non-competes. And when I live in this world, I'm always kind of looking in the rearview mirror from the perspective of a company. I've gotten in my time machine. I've kind of come to the end here, and I'm looking back now and thinking, what would have been different had this company planned differently in the beginning, which colors my entire, informs my entire approach to clients, even startups when they come in. We work a lot with startups. I start with the acquisition game in mind because I've got it emblazoned in my head after 30 years of doing this. That awful process that people go through. It can be a good process, can be a really awful process when those embarrassing questions start coming up and you start being asked to provide all this stuff and you come up short. Because that can affect the value of the company, it can affect whether or not you get, how you get paid. You might get an earn out, they may not have enough faith in you to give you cash, or they might at worst walk away from the deal because your house is such a mess. So in the world of intellectual property, what does this mean? One thing we talked about, copyrights, right? Copyright is anything that you create that's an original work, the operative you, the person who created it, it's automatically subject to copyright. If you're an employee working for a company and you create a creative work and you're being paid for that as an employee, that's a work for hire. You'll see that in the copyright. You go to the copyright government website, you'll see that term defined. There's a very limited number of things that are works for hire. But suppose the company hired an independent contractor to develop some work product. That independent contractor owns the copyright. That was not a work for hire. Now, I'm oversimplifying, they're going to tell me that. But generally speaking, an independent contractor owns the work that they created. So unless you have a contract whereby the independent contractor transfers over the copyright to what they created, you don't own that copyright. And believe me, when I'm dealing, I'll do a lot in the sell side. When I'm dealing with the big law firm, they bring on people on big conference calls, these all hands conference calls, and they say, okay, now Joe from our intellectual property department is going to get on the line and he's going to ask you about, and they start asking these embarrassing questions about the contracts and did you have that language in it. That's just one example. The trademark is another example. They want you to list all your trademarks that are registered. That's an easy one. Had you invested a little bit in getting the trademark registered, that's really easy. That's actually very impressive to a buyer when they see that you took the time to register a trademark. And as I say, the longer the company's been around, that brand might have a lot of value. So you get the idea. There's numerous other questions that are on that due diligence checklist. So I sometimes have clients that come to me that might have been in business a few years and say, 5-10 years from now we want to exit. Probably, what should we be doing now? I actually have clients that ask that. I try to be proactive and make them think about that, but sometimes clients come and ask me that. And I'll sit down and with them, and if they want to take the time to do it, I'll actually give them a sample due diligence checklist and say, have fun with this. Go test yourself. Or sometimes I'll even give them a sample of representations and warranties from an acquisition agreement where they have to represent and warrant certain things that are true or not true. And that's also a very good exercise. But that's kind of forcing them to get in the time machine and go forward and then look back and say, now what should we be doing now that we're not?
I want to share on that subject, I want to share with you guys 2 war stories that are more applicable to startups. I had a client that was a seasoned entrepreneur. He had bought and sold companies, very successful businessman. And in doing so, he thought he could do it himself. He got into software. He had the idea to create this software for e-commerce. And he had known some guy that he had worked with before that was a software developer. So he went into didn't go into business with the guy. He engaged him as an independent contractor, developed the software. So he contacted me about 14 months into this contract. He had spent about $400,000 in software development. And he asked me to help him with beta test agreements. Hey, we're on the road to pilot and commercially launch this product. And I need to tweak the developer agreement. I want to make some changes to it. And I said to him, I said, do you have an agreement? He says, yeah, we have an agreement. I said, who drafted the agreement? He said, the developer drafted it, but don't worry, I negotiated it. Literally, that's what he said. I was like, fantastic. So how do you access the software? How do you access the IP? And he's like, well, that's part of the problem, what I want to talk to you about, because I'm having problems where he's not giving me access to the software code, the source code. I'm thinking, but you got a contract. Who owns the rights? I own the rights. You know, clients tell me it's certain. Okay, well, let me look at the contract and we'll see where we can go for negotiating. I looked at the contract. There is no work for hire in the contract. I had to be the one to tell him 14 months in, $400,000 in, sorry, you don't own the IP. He was pissed. And he hired a big litigating firm. Took him a year to get back to the same point. He finally got the software, threatened criminal actions, and so they came down with a hammer. I don't know how much he spent on the lawyers to do the litigation, but it lost him a year of time to get back to the same point of we're beta testing, or how do we do the license agreement and so forth moving forward. So that's example number one. Do it yourself, even with a seasoned entrepreneur. Don't do that. Just simply don't. Get somebody else just to double check stuff, all right? And that work made for hire is a very key, important document. If you want it and somebody else is doing the work, make sure it says that. Second important example, I have a client that has medical device technology, and her and her brother are in business doing this together. Wonderful. Brother has a girlfriend who wants to help out. So she's been helping with the technology. Oh, but I don't want to get paid. Not just helping out. I don't want to get paid for this. And I'm where Jeff is, thinking, okay, this company can end up being a multi-billion-dollar company when it gets to the final point. And if I'm a multi-billion-dollar company and this girl who did some work at the early stages breaks up with the brother, right? Now who's going to come out of the woodwork years later to claim that was my intellectual property, I was part of the invention of that, I should have ownership of it. So the way I fix that is I don't care what you pay this woman, $600, $6,000, $60,000, I don't care what it is, you're going to put in a contract in place for independent contractor, work made for hire, and whatever it is, you wrap it up and you put a nice bow on it and you say, I don't have to worry about her in the future. So that's kind of how you take care of that stuff.
You could still have to worry
Thanks.
about her though, right? Because if she says it's not enough, she can still come after you, right?
Well, at that point, she was still dating the guy, and she said she didn't want anything from it. And I said, no, you are going to cross your T's, dot your I's, make this problem go away before it even is.
How do you retroactively go back to what she already coded?
You backdate the contract.
Oh,
You could say, I'm entering into a contract today,
From-
effective a year ago.
Really?
Sure, why not?
Questions? It's now time.
So, all these IP stuff, I develop software, take it to market, and somebody comes later on saying I have a patent on part of the technology, and I prove that I developed this independent of any other stuff, right? do I have any rights, do I not have any rights? That's one. Second, if I did patent search at the beginning and nobody has it, I developed it, I sent it to market, somebody else came and protected it afterwards during the process.
I just, one comment I want to make about something that in your example that you brought up, and this is another key thing that I try to express to my clients. So there's a difference between patentability and infringement. And so I always recommend to people, whether you get a patent or not, if you're going to commercialize something, you want to do a freedom to operate analysis, which would search for that sort of thing. So that's not necessarily going to be found in a patentability search, but you can hire, a firm or a third party or whatever the case. Somebody needs to look into whether what you're doing is infringing on somebody else's patent. So when you said the guy, I don't know how you know the timeline.
No, this is hypothetical.
Oh, okay.
I mean, it may apply to me.
Okay.
Because
Now, if you don't have any right, you can't sue anybody, right?
no,
So-
somebody's suing me.
Oh,
because
okay.
I have this, that they had patented part of the technology. I'm in the health IT business.
Okay.
About to launch telemedicine, right? Telemedicine out there. Somebody has developed or patented a piece of that I have no knowledge about. And I came up with this idea independently without having any intention of infringing on this person's rights
Right.
of intellectual. And I have all the documents to prove that this is all my own creation, independent of that patent. Because, in the, in the newspaper, you always see this company is suing somebody else for infringement rights. Apple paid somebody, or Samsung paid Apple, somebody paid somebody tons of money for infringing on somebody's patent. I don't know if they stole it, they didn't steal it, but they ended up paying money. So if by any chance somebody come in.
Are you saying
Somebody.
that you think you are the first inventor? Okay, well then
Of
it's,
my I'm developing this technology, it's my technology, I'm putting out of the market. But this is nothing, the technology is not novel, but my use of it is new. But somebody may say, I have patented this technology or pieces of that, this one way you're doing certain things patented.
right. So the patent rights are rights to exclude others from making, selling, using. And so short of you maybe trying to prove you're the first to invent, if they're alleging that, an analysis would have to take place. You should see if someone can do a claim analysis, because it's based on their claims, to see if what you're doing is infringing on the claims. But just because you created it independently, that's the power of patents. That's why they're harder to get, because it's a broader protection. It doesn't matter if two people independently created it. The first person, yeah.
First to register, right?
So
First to file.
That's what I meant.
Right. So ultimately, it comes down to, if you're not the first to file, it doesn't matter. Your knowledge of somebody else's patent rights are only relevant when it comes to the amount of damages that you have to pay. So it's the difference between an unknowing and being a willful infringer. If somebody else has patent rights, if somebody else is the first to file, the United States used to be a first to invent system, and then they went to the rest of the world and became a full bureaucracy and became a first to file system, right? So the person who fills out the form first is deemed to be the inventor. But once somebody's a first to file, you have to show that what they're claiming to own as the patent was actually in the public domain, and you have to try to invalidate their patent, or show that you do not infringe upon their patent because you don't do something that is part of the claim that they have in their patent.
Just a quick question on the copyright issue, especially because you said 3 months is kind of like the great time. We've been using a mark and some other things for a while, but then we just finished rebranding. I think the website's launching today, relaunching. So the mark is new, the logo's new, some statements are new. Does that kick us into, even though it's the same name, which we've just used the TM, we haven't actually registered it, does that let us start the clock ticking with the launch of all these materials as of today?
You're talking about the 3 months?
Yep.
The 3 months is for copyright, not for trademark.
Yeah. Okay, so for copyright, I'm meaning that we have a new website, we have some things that are works of art that are, are part of our process and everything, but that's all just being launched today. So even though we have operated using some of these things before, now that it's in a medium, online and print, can our 3 months start with the, with that stuff going public?
If you take an image, right, that you mentioned there were images as
Right.
part of the thing, right? So if you took that image and you created that image a year ago, and now for the first time putting it on your website, offering it to the sale to the public, then it's 3 months from today.
Great.
If you use that image to do other marketing material and offering your services to the public a year ago, then no.
Okay. Good. And
So
we'll
the-
make an appointment with you guys for the rest of the
So the
we have learned of our ignorance.
So the text that's on your website that's been out there,
It's actually all new as of today.
so if there's anything that you're reusing, whatever you're reusing, you can still register it, you just don't have access to those additional rights.
Okay, that's great.
And there's more to it than that, but yes.
So you've mentioned that obviousness is what you see that your clients get caught up on the most, and that the examiner is looking at it from the broadest type of interpretation. Can you talk a little bit about that to help me understand what obviousness is from the examiner's perspective?
So I can use a very basic example. So let's say, and this is just for the sake of helping you understand, so this is going to be a very trivial example. But let's say someone's claiming this chair, and it's white chair, and it has 4 legs, and open back or something like that. So it might be harder to say, because if I say if you use a closed back, but let's make it even simpler. Let's say someone files a patent and they said theirs is blue, different color, or it's a little bit bigger or something like that. Those things are considered design choices, things of that nature.
Well, I've seen a few examinations before, so they typically say that it's obvious that one piece of art is obvious in view of somebody else's art. So they're really then bridging two things together, and they think that's obvious, and I don't. So why is it obvious to them when you had to go, across to South America to find that second piece of art and bridge those two together?
So in that scenario, typically what you have to do is you have to provide arguments to say why it can't be one combined, or you would say the combination of the two don't teach what you're claiming, or if you could say it frustrates the purpose of the primary reference, you wouldn't modify this in this fashion because, I don't know, this device operates this way, and so you can't just put a register here because it alters the way it operates. So you have to provide those kinds of arguments to sort of diminish the substance of what the examiner is saying.
So like a chair with a scale in it.
Yes.
Yeah, I mean, that's why I said it gets very subjective. However, I mean, if you can show, first of all, you have to be, one thing that I find sometimes, the combination doesn't necessarily really teach what they're saying. So you can make that argument. Look, this is not the same, or that sort of thing. And then, your secondary arguments would be the things I just mentioned, like it frustrates the purpose of the primary reference, you can't combine them, things like that. But that's sort of the process.
The obviousness rejection is frustrating to everybody that's in the process.
Yeah.
Because it's subjective. And so, it's supposed to be what is obvious to one of ordinary skill in the art of those inventions, given, one of ordinary skill in the art knows everything that's in the world. That's not really what one of ordinary skill in the art knows. So It's very frustrating.
Yeah.
And so you have to, and Kimberly's touched on all of the different types of arguments you have to make. That being said, and the patent examiner may just say, you know what? I look at these things on a daily basis, and that's not the way I see it.
Yeah.
And you can end up getting in fights. I have a client who had it, and the combination uses references that are 100 years apart. And my argument is like, somebody would have, this has a commercial success, which is one of the arguments you can make. And if it was something that's commercially successful, somebody would have put these pieces together in the last 100 years. But they say that's just not the way I see it. And then you go through, you can go through appeals processes, and you can literally go all the, some of these cases go to the Supreme Court. And so.
Peter.
I've got a know-how question. I mean, I think I understand how artifacts can be protected. I think you folks have done a great job explaining that. But know-how, how is know-how protected? Do you have to be free of work for hire in order to have your ability to do things protected?
Well, work for hire has nothing to do with patents.
So know-how.
Not with patent, but
Well,
to
typically.
create something, you need to know how to do something. Whether it's products or, creative artworks or things like that. So I'm not trying to limit it to copyright, trademark, or anything like that. I'm struggling with the know-how question. How do you protect know-how?
So a lot of know-how falls under trade secrets, but the question, it can be kind of broad, right? Because the know-how could be a process, which could be a patent. So I guess it depends on what it is.
Do you run into the same trouble with the process patents that you do when it comes to the obviousness? So for example, our company does something that no other company is doing yet in its totality. But any one of the pieces you could find being done all the time. So we have a process that we created to deliver this particular service, but any one of them you could look at and say, that's basic.
Right,
That's
so
basic.
so let me say this. I only mentioned that to you guys just to say what some of the challenges would be, but we're versed at this. We can get you through now, but but we know how to, make counter arguments, or you have an interview with the examiner, look, this is whatever. There's a bunch of different stress, so don't be put off from that. This is normal, this happens a lot, it's just,
I suspect it's like a negotiation, really.
Yeah.
People start here, but they all come to the center. It probably works very similar in how they're bantering back and forth between the patent officer and themselves going back.
So
and forth.
Chris is standing, so but to your thing, know-how is protectable. Your know-how is basically your trade secrets. Okay? Protecting your know-how, though, goes back to what Jeff was talking about in terms of copyrights. If you take your know-how and you put it forth in a course, right? You protect that expression of your know-how, right? It's a creative work that's taking your know-how and putting it on paper. All the other stuff that's rattling up around there is still your trade secret, because it's the compendium that you have in your mind. Putting that forth into a form makes it protectable. And just like you can't stop an experienced, marketer, an experienced somebody that's been developed as a software coder, somebody becomes good at writing software. You can't, when they leave your company, you can't take the fact that they're a good developer now away from them, or they're a good teacher, they're a good coach. That's the inherent knowledge in there that's not assignable and ownable by anybody in particular, but that's experience, right?
I have a quick question.
One last question. Go ahead.
Crossing things. So I have friends that have trademarked their grains, their rare grains, and they've asked me to draw them. So when I put my copyright on my drawing, am I getting into some kind of gray area here? If they've trademarked a grain name and I use that trademark name in the title of a drawing, is there an issue?
You want to have a license to utilize that trademark for that purpose.
Yes.
That's what I would say. I would say, they're asking you to do this, memorialize it, so in their request, should be written, just say, they give you a license to use
That could be one
their-
sentence.
Yeah.
It doesn't have to be a big
Okay.
50-page
Yeah.
agreement.
Okay.
Yeah.
I hereby license you your
Yeah.
non-exclusive
Something
license
very
to
If
use
you
for this
were,
purpose.
if you were advising her client, you would advise her client differently, right?
No,
No.
because it's in her client's best interest
Right.
to have her render the grain, right? So there's joint marketing types of agreements that happen all the
So
time.
the licensing,
Companies
you're
want
saying
to.
for marketing.
Right, but
purposes.
I would advise her client to say, limit it just for this purpose. You're not getting
Right.
my rights to, my logo to put any which way you want on wherever you want. No, it's for this sole
I'm
purpose.
just asking, because earlier you said, work made for hire, should the client pursue a work made for hire?
Oh, I didn't realize that was the type of agreement that she was doing. She was
It's
not.
not,
it-
it's
it-
not.
She's an artist, so she does renderings. So the renderings, the question that she's saying is, does the renderings then belong to your client, or do you maintain ownership of that? And that, if you want your client to own those renderings, then the document, it would be a work made for hire.
Wouldn't she want to have, I mean, isn't there separate things she could do so that she can also include it in her portfolio? As you think about that, it'd be shown
You
again and again.
exclude that, or that's one of the ways that you can utilize it. So you give me a license to use your name for my marketing and promotional material, so that I could go tell people, hey, I did work for ABC Company, right? So there's ways you could do that all contractually.
That's why you go to the contract guys, because you can lay out exactly what you want.
And
And
we'll
go
put
back.
it down in writing and make sure what you want is there, and what you don't want is there.
Unfortunately, we've got to stop. We've got some time constraints. I think based on what we've heard, the questions that you've raised, I think we covered some important stuff tonight. At least that's my impression. So, my 4 questions. What have you learned? Who have you met? What do you need? And how can we help? You don't have to answer that now, but I'm asking you as you go home this evening, think about that. And please do me a favor, go out on our website, our chapter website, click on that link and fill out the survey. That's the best way for you to provide that feedback, okay? Because if left to my own devices, I am gonna have one senior moment brain fart after another and never remember one doggone thing that you asked me. And I'll end up with a lot of egg on my face. So, ladies and gentlemen, thank you so very much for coming. I hope that you got as much value out of it as I did. Like I said, I know 2 things about IP. 1, to be incredibly dangerous, and 2, to be incredibly stupid. Well, guess what? I just took incredibly stupid to a whole new level. That being said, thank you for attending. I hope we as a team see you back here again on a regular basis, because we're just really getting started with this kind of stuff. So thank you.